I will ask, I've got to look at the participants. Can anyone tell me if there's more than what I see on the screen? I only have 1, 2, 3, 4, 5, 6, 7 members. Is that correct? Or are there more?
I see 8. Warren, Newman, Rudnicki, Costain, Pickett, Lookner, DeChambeau, Morales.
Oh, I don't see Morales. Okay, thank you. Good morning, everyone. We're all set, Deb?
Somebody has the YouTube on. Can you turn that off?
Okay.
Yes, but somebody's got YouTube on in the background and needs to be turned off. Okay, we're good.
We're good? All right. Good morning, everyone. And welcome those who are watching us or hearing us, I should say. This is the Wednesday, February 10th, committee meeting of the Criminal Justice and Public Safety Committee. I will begin by introducing members or have them introduce themselves. My name is Susan DeChambeau. I am the Senate Chair, and my area is Biddeford, Dayton, Hollowell. No, not Hollowell. I'm sorry, I was going to take over Hollowell.
Back off, Senator.
Biddeford, Dayton, Lyman, Alfred, Arundel, and Kennebunkport. I'll take South Portland too. Okay, Representative Warren.
Thank you, Senator DeChambeau. I don't blame you for wanting to represent Hollowell. I'm Charlotte Warren, and I represent the city of Hollowell and the towns of Manchester and West Gardner. Thank you. How about I take a turn today? Representative Newman.
All right, I'm Dan Newman, District 76, which covers Belgrade, Rome, Mount Vernon, Fayette, Vienna, and Wayne.
Representative Rudnicki.
Good morning. I'm Shelley Rudnicki. I represent House District 108, which is Fairfield, Mercer, and Smithfield.
Representative Costain.
Good morning. I represent House District 100, which is part of Etna, Dixmont, Newport, Plymouth, and Corinna.
Representative Pickett.
Good morning. My name is Richard Pickett. I represent District 116, the towns of Canton, Dixfield, Hartford, Mexico, and Peru, and the beautiful white mountains over in Western Maine.
I like it.
Representative Lookner.
Hey, Grayson Lookner here in Portland, District 37. Right along the Fore River. I'll claim the airport too, unless Representative Morales wants it.
Representative Pluker.
Thank you. This is Bill Pluker, House District 95. I represent Warren, Hope, Appleton, and part of Union. Thank you.
Representative Morales.
Thank you, Representative Morales. I represent House District 33.
Oops.
Are we all set?
We'll go to Representative Reckett. Representative Morales froze up for a second. Representative Reckett.
Morning, my name is Lois Reckett and I represent, excuse me, represent District 31, which is the ocean end of South Portland.
Representative Morales, you want to try again?
Oh,
Okay, I think we're set. Thank you, Senator.
okay. And today, Senator Serway has an excused absence, and Senator Lawrence is not available, I believe, today. If he is, he'll show up a little later. We also have with us our policy analyst, Jane Overton, and our committee clerk, Deb Fahey, who keeps, I'm sure she keeps all of us in check, but she sure heck helps me, so I thank her. The same goes to Jane. I want to explain the process a little for those who are listening and are new. We have two bills we're going to be hearing today, and I'll say them as when we're ready to hear them. The process is the sponsor will present the testimony of the bill, followed by any co-sponsors who are available and wish to speak. And also we give some leeway to any legislators who may want to speak in favor or in opposition, because legislators also have other hearings they have to attend. We'll then open it up to anyone who wishes to speak in favor, followed by anyone who wishes to speak in opposition. We will end with testimony of those who wish to speak neither for nor against. And then after every speaker, we'll open it up to questions, clarifying questions from the members of the committee. So with that, and welcome Senator Lawrence. He has joined us. Would you introduce yourself, please?
Thank you. Thank you, Senator DeChambeau. I'm State Senator Mark Lawrence. I represent District 35, which is Southern York County, the towns of Kittery, Elliott, South Berwick, Havre Berwick, York, and Ogunquit.
Thank you, Senator Lawrence. So without any other questions or comments, we will begin. Yes.
Thank you. Can we just let folks know, as we are embarking on another day of public hearings, we have heard back from IT, and they are almost at the place where what we've requested regarding testimony will actually exist. So what that means is, as far as I understand it, as the emailed testimony comes in, it will be automatically loaded to a folder within committee materials on our committee website, which will help us very much. Not quite there yet for today, but looking at that in the future. Also, we've had an issue around the Office of Information not wanting Deb to send out the Zoom link to our personal emails. We've sort of sent that along, that conversation along, and I think we'll see a change there as well. We can certainly understand that when it has to do with, freedom of information, our clerk shouldn't be sending us policy issues to personal emails, but Zoom links, I think we can probably figure that out. So that's the only way we can easily get it put on our calendars. And I know that these things are pretty frustrating. So hang with us. Hopefully by the next time we have a public hearing, we'll have these things figured out. So thank you, Senator.
Well, I thank you, Representative Warren, for working on that. It's going to be
Senator?
Yes. Yes, Representative Pickett?
Yes, thank you. Just going back to the procedure, I think in the hearings we had on Monday, I think there was at least one of them where we had, I believe it was a sponsor that gave their testimony. We had our question time, and then as we got into the other people speaking and stuff, there was a request to go back and speak to the sponsor again. And because of the virtualness of our meetings and stuff now, where we're not in person in the committee room, where this isn't a work session, once a person has testified and we've asked questions, at that point there, I believe the procedure is supposed to be the mic is shut off and they're done until the work session if they come back, just for process. Thank you.
Thank you. And yes, thank you. I don't recall that, but I'm sure it happened. All right, let's proceed then. The first bill we're going to be looking at is LD 58, the title of which is an act to improve information sharing by criminal justice agencies with government agencies responsible for investigating child and adult abuse. And we have with us the sponsor, excuse me? We have with us the sponsor, Representative Harnett. Welcome.
Thank you very much. Good morning, Senator DeChambeau, Representative Warren, esteemed members of the Criminal Justice and Public Safety Committee. My name is Tom Harnett, and I represent House District 83, which includes the town of Farmingdale and the city of Gardner. I'm pleased to join you this morning to introduce LD 58, an act to improve information sharing by criminal justice agencies with government agencies responsible for investigating child or adult abuse. This legislation is proposed by the Maine Department of Public Safety. LD 58 will amend current law to allow criminal justice agencies to share a broader range of investigation-related information with the DHHS Office of Child and Family Services, as well as with similar offices in other states. As a result, the Office of Child and Family Services will have access to additional information that will be used by that office to help better inform its investigations of suspected abuse, neglect, and exploitation of children and incapacitated or dependent adults. Protecting our friends, neighbors, and community members who are subject to that type of abuse is a laudable goal that I support, and one that I imagine on which we all agree. Children and incapacitated or dependent adults are among our most vulnerable citizens. I understand there is a representative from the Department of Public Safety here today who will be able to answer any questions that you have. I also understand that you might hear from others with concerns about the breadth of this proposal. I encourage you to take your time, listen to all interests, and craft a bill that makes sense to you that balances the rights of all concerned. I'm happy to work with the committee and interested parties through this process. Please let me know how I can best assist you. While I'm happy to answer any questions you might have, I do know that there are others in attendance who are far more capable to do so than I am. Thank you very much for your time and consideration.
Good. Any questions for Representative Harnett at this time? Hearing none, thank you again. And I will ask if there are any co-sponsors who wish to speak on this bill available. Seeing none. All right. Any legislators in attendance who wish to speak on this bill? All right. Now, those in favor of LD 58, we're ready for your testimony, please. I think I had a list here. 180. Is that from the Maine State Police, Attorney Parr, Christopher Parr? Is he with us? Someone?
He's just joining.
Okay. I'm not good at multitasking this thing.
Deb, if you know all of the folks that are here for this bill, it might be easier. I hope I'm not messing up some procedure, but it might be easier just to let them all in, or is that messing
Sure.
up some procedure?
Yes, I agree. Yeah.
No, I think that might be the easiest
Okay,
thing
great.
to do.
Thank you.
I will do so.
Thank you.
Welcome, Attorney Parr. I'll get to you in a moment. I want you to know that from Health and Human Services, Dr. Todd Landry will be speaking also, and Ken Mason and John Pelletier. So welcome, Chris.
Hi, good morning. Yes, and please call me Chris.
Okay.
Senator DeChambeau, Representative Warren, members of the Joint Standing Committee on Criminal Justice and Public Safety. Good morning. My name is Chris Parr, and I am here today to testify on behalf of the Department of Public Safety in support of LD 58, a bill that was proposed by the department. As an initial matter, I want to thank Representative Harnett on behalf of the department for his willingness to introduce this bill for DPS. Current law permits the limited sharing by criminal justice agencies of confidential investigation-related information with the main Office of Child and Family Services at DHHS, as well as similar agencies in other states. That ability to share information, however, is even more limited because the information that can be shared must specifically relate to past investigations of suspected abuse, neglect, or exploitation of children or incapacitated or dependent adults. Because of that additional limitation, criminal justice agencies such as the Maine State Police are unable to also share investigation-related information that may not relate to such investigations, but that might be just as important, if not even more important, to provide to the OCFS so that that office has sufficient and relevant information it needs to more fully inform its own child and adult protection investigations. LD 58 would broaden the law to permit criminal justice agencies to share investigation-related information with OCFS, regardless of whether that information relates to past investigations or investigations of suspected abuse, neglect, or exploitation of a child or an incapacitated or dependent adult. As a result, the OCFS will have access to more valuable information, which in turn will help to ensure that some of the most vulnerable individuals who live in our communities are safe and protected. For those reasons, the Department of Public Safety very much encourages the committee to move and endorse an ought to pass report for LD 58. Thank you, and I'd be happy to try to answer any questions you may have.
Turn it over to the members. Anyone? Yes. One moment. I have a way of doing this. Representative Reckett, followed by Representative Warren.
Thank you, Senator DeChambeau. Mr. Parr, I just have a question about the things that might be shared. What's going on in my head is I'm familiar with cases where Child Protective is investigating a mother on a child abuse complaint or situation that involves domestic violence. And I want to be clear that that information would, if it's in the hands of the department, would be able to be shared with Child and Family Services as well. Is that accurate?
I think so. I'm trying to think of an example of where that might happen. But I would say that if the office knew about that, that had, knew that some sort of investigation was or did happen, that they would inquire about that. And I think that is something that we would, under the statute, be able to provide if LD 58 passed. The problem right now is that because that investigation, if it didn't relate to, under the current statute, if it didn't relate to suspected abuse, neglect, or exploitation of children or incapacitated or dependent adult, that's the problem with the current statute, is we wouldn't be able to provide that currently. If LD 58 were to pass, though, we would be able to.
Yeah, because I'm clear that even though the Department of Human Services is not supposed to be taking into account or calling things by particular terms that are out of date, they sometimes do. And so women get caught in a failure to protect circle that is impacted greatly by the existence of a domestic violence complaint on the other side. So, all right, thank you very much. If you find out that's not true, will you let me know?
Yeah.
Okay,
yeah.
Thank you.
Thank you.
Thank you. Representative Warren.
Thank you, Madam Chair. My question, Mr. Parr, was just for, could you give us some specific examples of what problem this bill is attempting to fix? I'm trying to get my arms around it.
Sure. Yeah, no, it's a great question because it is kind of confusing. So right now, under the current law, if we have the ability to share investigative information but that information can only relate, we can only share that information if it relates to past or current investigations of suspected abuse, neglect, or exploitation of children or incapacitated adults. So if, for example, we had investigated someone in the past who was involved or the subject of Office of Child and Family Services and child protection investigation, for example, and that person had a history of assaults or violent criminal activity, but we wouldn't be able to share that information under the current law because it wouldn't relate to suspected abuse, neglect, or exploitation of children or incapacitated or dependent adults. So say, for example, this person assaulted someone, their neighbor, or someone at a bar, because it doesn't fall within that narrow scope of what the statute allows, we would be unable to share that information. Another example would be if someone had a history of drug trafficking or drug use, we wouldn't be able to share that information because there's no, there wouldn't be that connection to suspected abuse, neglect, or exploitation of children or incapacitated or dependent adults involved. So it's really trying to ensure that information that might be relevant or helpful in informing OCFS's investigations, that they're able to, that office is able to get that information.
And just to follow up, what's the purpose of sharing somebody had an assault down the street or has a previous drug? Can you say more about what's happening that you need to make this change? Still trying to understand what you're going for here.
Yeah, so, and I think OCFS would probably be able to speak a little bit better, and I believe they're going to be testifying. But if for example, there's a situation where a child is potentially being abused, then having information that, well, this suspected abuser does have a history. In fact, here are some other cases where they engaged in violent conduct against adults, and this information sort of helps OCFS build its understanding of, you know, what's going on here. Is this person, does this person have violent tendencies? And so having that information about, say, past assaults that this person committed would help them understand, you know, what's going on, and this person's possible disposition to violence that they may be engaged in abusing a child.
And what about the drug crime portion?
Well, again, if there's a child endangerment issue or a neglect issue, and there's evidence that there was some sort of drug use going on where it would suggest that this person might be unable to adequately care for a child, then that OCFS I think might find some value in that information.
But isn't it that if it's part of a current investigation, it already can be shared? This is specifically about previous records. Sorry, I'll stop asking questions, but I'm still trying to understand.
Yeah,
isn't current already able to be shared?
If it's within that subset, it would be current investigations and any past investigative material.
Okay, thank you so much. I'm getting a better picture. Thank you.
Okay. I would ask those who have spoken, make sure you lower your hand after you speak. So who we have wishes to ask a question is Representative Morales, followed by Representative Lookner.
Thank you, Madam Chair. I'm sorry, it's really noisy in my house. Can everyone hear me okay?
Yep.
Okay. I'm also trying to understand this, and I know probably Dr. Landry will be able to fill us in on more of the need for it, but I'm having a hard time understanding that. So are you saying that Child Protective and OCFS, they don't have the ability to access publicly available criminal justice records of past convictions? Or is this not involving past convictions at all in the criminal justice realm, but that you're wanting to access past or current investigations by police that haven't yet become convictions?
It would be investigative material as opposed, so you have criminal history record information, which is basically records of conviction, arrest, that sort of thing. And then you have the investigative material, for lack of a better description, police reports that are the narrative and the evidence that's accounted for in a police file that may or may not relate to incidents resulting in a conviction. So, and that's very important, is that, some of this information may relate to investigations that did not ever result necessarily in a charge by an officer or by in a conviction if the matter was prosecuted. And I think that's a very important aspect of this that the committee needs to consider.
Okay, I do think I understand that. So all the investigation, which could include information that the prosecutor didn't believe was enough to prove that there was a crime involved, but that information could be relevant for investigation purposes for OCFS.
That's exactly right. It may be that, that we're talking about evidence that's collected by a law enforcement officer or officers, depending on how broad the investigation is, that hasn't been tested necessarily in some cases in court, but that still might provide some degree of information that would be helpful to OCFS.
Thank you.
You're welcome.
Representative Lookner.
Thank you, Madam Chair. And my question is just real specific, and Representative Morales was sort of getting to that point. If a parent has a conviction on, any kind of conviction, then these agencies can already see that, correct?
OCFS, I believe that OCFS now has access to both public criminal history record information, so that any member of the public would be able to get. And I think, and the person will have to confirm this for me, who's going to be testifying, I think they also have information to what would only be accessible to law enforcement agencies.
So if it's public, why wouldn't they be able to use it?
I think that they could certainly use the criminal history record information. What's not public, what's confidential by statute, what's protected by statute under Title 16 are the investigative records, because of the volume of very sensitive, private, personal information that can often be included. That's something that's very much addressed in the statutes and made confidential.
Okay, thanks.
Yeah.
Anyone else? I just want to make a comment on the bill. Reading what is underlined and what's crossed off, but the summary and Representative Hunt, if you look at that, I question it. The summary, it has nothing to do with the bill, but it expands the authority of criminal justice agency. Is the Department of Corrections considered a criminal justice agency?
I want to look at. Oh, I'm sorry.
Go ahead, Chris.
I'd want to look at the definition. I think so.
Yeah. Okay. So I'm a little confused. I don't see anything in the bill that would make reference to that. And I guess I just want to point that out to anyone who just reads the summary. This does not include the Department of Corrections, does it? I mean, I don't understand what kind of confidential information they would have unless they're dealing with juveniles and they report a matter of abuse at home.
Yeah,
Do you understand what I'm asking? Yeah.
yes. The definition of criminal, there's a definition of criminal justice agencies in Title 16. And
Okay.
I can find that. I'm finding it right now as I speak. And that way, the definition of criminal justice agency, and it's broad, so as you'll hear, criminal justice agency means a federal, state, or state of Maine government agency, or any subunit of a government agency at any governmental level that performs the administration of criminal justice pursuant to a statute or executive order. Criminal justice agency includes the Department of the Attorney General, District Attorney's Office, and the equivalent of departments or offices in any federal or state jurisdiction. Criminal justice agency also includes any governmental agency at any level of Canadian government in the government of any federally recognized Indian tribe. Yeah. And one of the terms that's used in that definition is the administration of criminal justice. And that means administration of criminal justice means activities relating to the anticipation, prevention, detection, monitoring, or investigation of known, suspected, or possible crimes. It includes the collection, storage, and dissemination of intelligence and investigative record information relating to the administration of criminal justice. So I think that by that there is, I think corrections does certainly have a role in the anticipation and prevention of future crime in terms of,
Okay, that's the question I have, and it's my last question. The government agency. So would the Department of Corrections be involved in this or be subject to this?
It's a great question. I only think of this in terms of when we as a law enforcement agency are getting these, but I think I would imagine OCFS, the person who's going to be testifying, I'd imagine will know, if they make those requests to the Department of Corrections. It's a great question. I'm not quite sure.
All right. If anybody that has a question, an answer, I'd appreciate it. All right. Thank you very much. Not seeing any other raised hands. Thank you very much. I will ask if the next person is Todd Landry. Welcome.
Thank you very much. Good morning, Senator Deschambault, Representative Warren, members of the Joint Standing Committee. I am Todd Landry. I'm the Director of the Office of Child and Family Services within the Department of Health and Human Services, here today to testify in support of LD 58. As you have heard, this bill will expand or would expand the authority of criminal justice agencies to share certain confidential intelligence and investigative records with the Office of Child and Family Services. Now, currently, as you've heard, the authority for criminal justice agencies to share their information is contained in paragraph 1 of section 806. That section also contains a requirement that to share intelligence and investigative record information, that information must concern the investigation of suspected abuse, neglect, or exploitation. The bill as proposed would create a new section within that requirement, which would ensure criminal justice entities can share information without requiring proof of that defined nexus between the information requested and potential abuse, neglect, or exploitation. This change will expand OCFS's ability to obtain investigation and intelligence information, which we believe is critically important to our office's work to ensure child safety and well-being. Now, this bill would solve what we see as a significant issue with our current ability to obtain information that pertains to child safety and well-being, regardless of the nexus between the crime investigated and the child. So as one example, and I think this goes to, I believe it was, I'm not positive here, but one of the questions that was asked about domestic violence. So for example, Currently, OCFS can only obtain records of a domestic violence incident if the child was present during that incident. Domestic violence, as we know, can have serious implications for child safety and well-being, and any incident of domestic violence involving a parent may inform a child welfare investigation or case decisions, regardless of whether or not the child was actually present for that specific incident. The change proposed in the bill would enhance OCFS's child safety decisions by providing staff with a more complete picture of a parent, guardian, or other involved adults' criminal justice involvement. I urge you to support LD 58. I thank you for the opportunity to testify. I'm happy to answer questions that you have or provide additional examples that go to some of the questions that you were just asking. So I would point out that I do have some answers for some of the questions that you may have as it related to drug investigations or drug searches. I'd be happy to give that answer or example to Representative, I believe it was Lookner's question as it relates to convictions. And that piece, if you want to ask that question again, I'd be happy to try to answer it from our perspective. But not knowing where you might want to go next with those questions, I'll end my formal testimony and turn it back over to you. And again, thank you for the opportunity to be here.
Thank you. Yes, I have Representative Costain, followed by Representative Pluker, and then Representative Warren.
Thank you, Madam Chair. Mr. Landry, my question would be, you're asking the agencies to share information with DHHS. Is DHHS going to share information with police agencies as well? Is it going to be a two-way street?
Yes. So currently, any request for that information, goes through, goes through our process, including, if needed, review by the Office of the Attorney General. But we are able to share that information back with them unless it's prohibited by some section of law. But to my understanding, we're able to share our information with them, but it's not necessarily the true and reverse. And I can confirm that, after today's testimony, but that's my understanding.
Yeah, my experience in 35 years is that DHS always wants information from us, but for us to get information back from you guys, if you work in a criminal case or something, it doesn't work that way.
Well, I don't doubt your 35 years of experience. I can only speak to my last nearly 2 years of experience here, and I know that we have shared information on a relatively frequent basis.
Thank you.
Representative Pluker?
Thank you. I have a couple questions. One, you mentioned domestic violence couldn't be something, or an issue of domestic violence wouldn't be shared. And I'm just looking at the last sentence of this statute where it says investigative record information concerns the investigation of suspected abuse, neglect, or exploitation. Wouldn't domestic violence fit into that definition of suspected abuse? Because it doesn't explicitly say in the statute that abuse must be of a child. It just says suspected abuse, period.
Currently, as the statute is currently written, the way it has been interpreted and enforced is you must be able to demonstrate that clear nexus between that specific event and the investigation of the child. So or investigation of a potential abuse or neglect of a child. Using my prior example, domestic violence right now, if there was an incident where the child was not present, we cannot currently have access to that information. But clearly, it would be potentially quite important to us to have that information as it relates to our investigation of the safety of a child in that home.
And so when that interpretation that you're working with, is that in rule right now?
I'll find out exactly where that is, whether it's in rule or whether it's been determined through through a court proceeding. I can't speak to exactly where that has been codified, but we can find that out and get back to you.
Thank you. I think that would be important for the work session. And then I had another question around the definition of neglect as it pertains to drugs. And so we would say that if someone has some sort of investigative history with drugs, but they've never been demonstrated to show any neglect to their children, this would allow, if they had issues with drugs and there was neglect, then this would under current statute, you'd be able to share access or get access to that. But if they had a history of drugs, but there had been no neglect, then you would not be able to share access.
Yeah, that's pretty close to the way it works right now. So let me give you another example that may be illustrative in this situation. And so, and I should say, all of these examples are real case examples, and so we're not just theoretically making these up. So the example I would give you is, let's say there is a drug search, or using the vernacular, a drug bust, and it pertains to an out-of-home dad's or father's house. And so in that case, the child is not residing with the father at that moment in time, but a drug bust occurs. Soon after that, the department determines that the mom, where the child is currently residing with, for whatever reason, is not safe to or not able to care for that child. And we actually reach out then to the dad, as we would, since they are the parent and a relative, to possibly care for the child. Using that example, currently, we could not obtain the investigative records of that recent drug bust or drug search because the child wasn't present in the home.
It wasn't living.
So that's another example that I think speaks to a situation where it would be very beneficial to know that had occurred, so we can look into that further, of course, while making that determination of a safe and appropriate placement for the child.
And thank you, I appreciate that. And then my last question is, I see that the statute involves sharing information with other states. And how much experience do you have with sharing information with other states? And would their own statute preclude them from sharing it further after that point?
Yeah, I think it would depend significantly, of course, on those other states. But we are able to share with information with other investigative agencies at other states. As you might expect, here in the New England region, there is a fair amount of movement of individuals across state lines, and so we're able to share some of that information. This would also make it possible for, as I understand it, for example, Maine State Police to be able to share information with those other states, and as a course of their investigation.
Thank you.
Thank you. Representative Warren?
Thank you, Madam Chair. Thank you, Mr. Landry. That example both of those examples you gave me a better understanding of what we're going for here. And just to put a really fine point on it, as far as the drug bust example, if the person was actually convicted, you would already have access to those records. So you actually, even if somebody wasn't convicted, so they're not guilty in the eyes of the court, you want to still be able to have access to that information as if they were guilty.
Yeah, let me explain that, and I think it also speaks to the prior question by one of your colleagues. So you are correct. If there is a conviction, we can certainly see the conviction. What we don't have access to is any of the underlying facts related to that conviction, and that becomes important because when we're looking at those investigative records of convictions, they can also be very helpful to us, especially when charges are potentially pled down. And I think it's important to keep in mind in those cases that the OCFS standard, as it relates to child abuse and neglect, is certainly different than the criminal standard that is often applied. And in fact, it is lower because of the protective capacity and protective needs of children. So it is important to sometimes consider that we would also be able to, under this proposed bill, be able to see those underlying facts of that conviction, not just the conviction itself. And that that would inform us in many ways because of the additional data that we would then have to go on and information we have as part of our overall investigation to determine the safety of the child. So hopefully that helps to explain that and put a bit of a finer point on it.
Madam Chair, may I have one follow-up?
Thank you for asking. Yes, go right ahead. And
Thank you. Mr. Landry, I think I'm still misunderstanding. So let me try one more time. I get that part. There's a conviction. You want to have access to the investigatory records. Totally understand. Clear to me. What you're also going for, though, and maybe I'm misunderstanding, is even if there wasn't a conviction, so there's an accused, there's an investigation, there's maybe a drug bust, but that person is not charged for that crime. You still want to look at those records.
This bill would give us the authority to do that, yes,
Thank
and yes,
you.
it would, because it would help us in those situations, even before a conviction or even a charge is done. So using my prior example, that example was a situation where there had not even been enough time for the legal investigation process on the criminal side to even take place when that situation came up. So we would be able to access those records before the determination of charges or a conviction is held or is made.
Could you get to us through Jane what you referenced as far as what the standards are when it comes to investigating? I think that will be really helpful.
Sure,
Investigating child abuse, neglect.
You bet. We can summarize that for you, and then also, I believe, provide specific reference to statute of where that is codified.
Thank you so much.
Sure.
Representative Lookner, you had your hand up.
Yeah, thanks, Madam Chair. Thanks, Mr. Landry. The specific examples were really helpful for me as to understanding exactly why OCFS wants this. I'm just wondering, can you provide maybe some numbers or, without getting into too many details, more specific instances where real harm came to a child because, potentially OCFS didn't have access to these records and, a child wasn't removed from a situation where they were exposed to harm, or just, numbers, for instance, where is this a pervasive issue, or is this something that's only happened maybe only hypothetically?
Yes, we're happy to provide you with some more information to that point, to the extent that we know about it, of course. There may be situations that there was potential harm or potential neglect or abuse may have occurred that had a connection to some information that we didn't have access to, that we may still not know about, to put a point to. But for those that we know about, we can gather up some information and provide that to you in advance of the work session.
Great, thanks.
I don't see anyone else wishing to ask. Representative Morales.
Yeah, thank you, Madam Chair. And hello, Dr. Landry. Wondering just about, I definitely want to know some of that information that you're going to provide folks around standards and things like that. And wondering if you could kind of just give us the picture of OCFS and the families that you work with. When we are talking about criminal justice, we're often talking about folks who are indigent clients and qualify for free legal services. What percentage would you say of the families that are involved in OCFS are in poverty?
I can get you that specific information. I believe we have some of that information, and so I'd rather give you that specific information separately versus working off of the top of my head right now. So if you don't mind, we can share that information with you separately in advance of the work session. Okay,
that's fair. What would you say it would be, a high percentage?
I don't even want to speculate at this point, and so I have seen that data, but it has been a little bit of time, and so I hope you'll give me the latitude to be able to make sure I provide you accurate information versus taking a guess at this point.
Sure, of course. And one question, Madam Chair, if I may, thinking about, I'm trying to think what would the human outcomes be about this, and I could see the arguments of having more information to protect children, and then also the outcome of likely removing more children from homes and into some sort of care that the department would provide, and just wondering what kind of funding to pair together with this bill that you're thinking about? And I don't expect you to answer it now, and we can talk about it at the work session.
Yeah, happy to talk about it more at the work session. Certainly all of the avenues that we currently have available to us, whether it be through federal or state resources of funding, would apply to any investigations or any support for families, regardless of how the information came to us. I don't necessarily believe this would increase the number of potential removals of children. I think what it would do is give a more complete and accurate picture for our staff to make an appropriate determination about the safety of the children that they're investigating. There could be situations where we may have access to more information. We may then investigate and get more details from the family about what occurred, and it may not result in any actual change to the outcome. But it certainly provides us with more information and perhaps other services that would be beneficial to the family to help ameliorate or mitigate some of those concerns.
Thank you.
Thank you. We are still in those who wish to speak in favor, so I will, someone else, okay. I have, and I'm not sure if you're wishing to speak in favor or against, or I'm neither for nor against, but Sheriff Mason, are you going to provide testimony in support of this bill?
Yes, ma'am, I am.
Okay, go right ahead. Thank you.
All right. Well, it's very, very nice to be here again. Senator DeChambeau, Representative Warren, other esteemed members of the Criminal Justice and Public Safety Committee. I am Ken Mason, and I am the sheriff here in Kennebec County. And I am here on behalf of the Maine Sheriff's Association. We as sheriffs, we met to discuss this bill, and it was a unanimous position to support LD 58. Now, the Maine Sheriff's Association Legislative Policy and Committee, we reviewed this bill, expanding authority of law enforcement to share impactful information with decision makers, on the welfare of a child or an incapacitated adult is not only appropriate, but it's responsible as well. I can identify few, if any, priorities in the office of sheriff that rivals the well-being of our most vulnerable populations. Now, we commend the Department of Public Safety for recognizing the value in the language modification. Maine's 16 county sheriffs urge you to support LD 58 and pass as written. Thank you for your consideration, and I will do my best to answer any questions should you have any.
Thank you, Sheriff Mason. Anyone have any questions of Sheriff Mason? No? Thank you again.
Thank you very much. Good to see everybody.
Good. Now I have Mr. Pelletier, John Pelletier. Is he joining us? Hi, Mr. Pelletier.
Hello, good morning.
Good morning.
Senator DeChambeau, Representative Warren, members of the Committee on Criminal Justice and Public Safety. My name is John Pelletier. I'm the chair of the Criminal Law Advisory Commission. And we discussed this bill at our meeting last Friday, and are in favor of the bill. And there wasn't a lot of discussion because the members felt that this was a reasonable expansion of the sharing of intelligence and investigative information. And for the reasons that you've heard here today, that there may be information that is relevant to the protection of children or vulnerable adults in police reports and other investigative materials. I'll be glad to answer any questions. I've been listening to the discussion, and I do have a couple comments on some of the questions that we've had so far. Senator DeChambeau, you asked whether DOC is a criminal justice agency. And I believe that DOC does have some employees that are designated as investigators. And they would be charged with investigating crimes, maybe within the prison. But the definition of criminal justice agency and criminal justice administration of criminal justice would involve a DOC investigator investigating crimes in the prison. So I don't know whether the entire department or that branch of the department would qualify, but I'm quite certain that at least aspects of DOC are would meet the definition of criminal justice agency. Representative Pluker, if you look at the statute, you are correct that the very last phrase in current law does not specifically relate to the abuse or exploitation of children and vulnerable adults. But the preliminary language says the information will be shared with, and it's actually struck in the bill, with an agency responsible for investigating abuse, neglect, or exploitation of children or incapacitated or dependent adults. And so when later in that same paragraph, they use the shorthand of suspected abuse, neglect, or exploitation, I'm pretty confident that that would be interpreted to relate back to the prior language, so that current law does restrict the sharing of information to investigative materials related to abuse, neglect, or exploitation of children and vulnerable adults. Representative Morales, from my former position with the Commission on Indigent Legal Services, I can tell you that from my observation, a very high percentage of parents involved in formal child protective proceedings receive assigned counsel. And there are occasional cases where one party has assigned counsel and another party has retained counsel, but by and large, it's a large percentage. So I think that relates to a question that you had. And with that, I'll stop and answer, and be glad to answer any other questions that the committee members have.
Thank you, Mr. Pelletier, and thank you for making comments on those questions. That's helpful. Thank you. Anyone wish to ask Mr. Pelletier any question? It's great to be the fourth one to speak. There's no questions, okay? They've all been answered.
Well, when you're deciding who comes, the order, keep that in mind. I like this.
Okay.
Thank you, Senator.
All
Thank
right.
you, members.
Thank you. Those are the names that I had before me, but I'm opening it up if there is anyone else who wishes to testify in support of this bill. Seeing none, I will go. Anyone wish to testify in opposition? Seeing none. Anyone wishing to give testimony to neither for nor against? All right. So having no other questions, I will determine that this meeting is closed for this bill. I was going to take my my stapler as a gavel, okay? So the meeting is closed. So thank you.
Thank you.
All right, we're moving right along to our next bill. LD 180. Representative Perkins has submitted this bill, the title of which is an act to amend the storage requirements for consumer fireworks. And I have another a number of people who have submitted testimony, I believe. So we'll begin with the sponsor, Representative Perkins. Are you with us?
Representative Perkins is not here yet.
Okay. Representative Warren, should we hold off or?
Yes, please. Deb did reach out to the House Republican office to make sure that we can try to make sure he has the link, etc. So could we wait 5 minutes and make sure we give him the opportunity?
Yes, we have
Take
to.
a 5-minute break. Deb, also, will you be running the clock during this next public hearing?
I'm happy to give it a try.
Okay. I failed at it the other day. Every time somebody would start talking, I'd realize I hadn't started the timer. So clearly I'm not the person to do it. So yeah, let's give it, take a 5-minute break and see if we can get Representative Perkins.
Thank you.
Representative Warren,
Yes.
I just texted him. I'm waiting for a response back.
Thank you so much. Great.
Deb,
Yes.
yes, could you tell me, did Representative Perkins send testimony? Did you forward that to us? Because I can't find it.
I did not. Well, let me double check.
Thank you.
Senator DeChambeau, I did not receive any.
Yeah, okay, I didn't think so. Okay, thank you.
Senator DeChambeau,
Yes,
Representative Pickett is on the phone with Representative Warren, and he'll be on in a minute to let you know what's
okay,
happening.
thank you.
Senator,
Yes,
Representative Pickett is here to save the day. He is going to step in for Representative Perkins and present testimony, and then we'll keep on moving.
good, thank you. That was Plan B. Thank you, Representative Pickett. Whenever you're ready, we're ready.
Yes. Thank you, Madam Chair. My name's Richard Pickett. I represent District 116, towns of Canton, Dixfield, Hartford, Peru, and Mexico. And I'm here to present Representative Perkins' bill. He has been called to an emergency and unable to be here to present it this morning. The bill is LD 180. It's an act to amend the storage requirements for consumer fireworks. And the bill brings the laws governing the storage of consumer fireworks into conformity with a recent Maine court decision by authorizing the Office of the State Fire Marshal to regulate consumer fireworks storage by those authorized by law to sell consumer fireworks. And I will not be answering any questions but there are people coming behind me, I'm sure, that will talk in much more detail on this, including the Fire Marshal's office. Thank you.
Thank you very much, Mr. Pickett. Members who were here last year recall some of that, those concerns. So, but I'm sure we'll talk about it some more. So I'd like to, if there are any co-sponsors here of this bill, no, there were none. I guess it was just Representative Perkins. I don't see any other legislators who wish to speak before they go to another meeting. And so I will ask those who wish to speak in favor of this bill. Again, some people are new here. We will hear those in favor of the bill, followed by those in opposition and those who wish to speak neither for nor against. The first person I have is Richard McCarthy from the Fire Marshal. Richard, are you with us?
I am, Senator.
Great, welcome. Can you, you wish to give testimony?
I do.
Great.
So good morning, Senator DeChambeau, Representative Warren, and members of the Joint Standing Committee on Criminal Justice and Public Safety. My name is Richard McCarthy, and I'm the Assistant State Fire Marshal. I head the Inspection Prevention Division for the Office of the State Fire Marshal. I'm here today representing the Department of Public Safety and the Office of the State Fire Marshal to testify in support of this bill. In 2011, Title 25, Section 223A was passed by the legislature, and it became legal for people to purchase consumer fireworks at licensed retailers. Part of that original legislation included direction of our office to permit the retail sales of consumer fireworks. The statute was silent on storage of those consumer fireworks, and that is why I'm here today to discuss this issue. In May of 2020, there was a decision from the Superior Court in Kennebec County that required consumer fireworks retailers to obtain a storage permit for consumer fireworks that were being stored in a building that was not licensed to sell retail consumer fireworks. But the existing statutory language did not give us the ability to issue that permit. This bill gives the ability to our office to issue a storage permit for consumer fireworks retailers. It is our intent to adopt national standards, just as we did for consumer fireworks. Retailers charge a nominal $125 fee to cover the inspection and the administrative costs. And this bill will allow our office to be in compliance with the court decision and oversee storage of consumer fireworks by those licensed to sell consumer fireworks. This bill does not address private and personal use or storage of fireworks. So we're only talking about the stores that are licensed to sell. In conclusion, I urge you to support this bill. I'd be happy to answer any questions at this time or during the work session.
Very good. Anyone wish to ask questions of Mr. McCarthy? Representative Pluker.
Thank you, Madam Chair. So much of this bill seems to hang on this National Fire Protection Association Standard 1124. Could you give us some of the details of that?
Sure. NFPA 1124 is the, in our office, we adopt around 55 NFPA codes and standards, which are basically consensus codes. These are codes put together by groups, not just fire professionals, but professionals from different industries. So one of these is actually NFPA 1124, which is basically the standard for consumer fireworks sales and storage. and also the manufacturer of consumer fireworks. So this would give us a national standard. This standard is adopted in a number of different states that actually allow for consumer fireworks sales and use. And this actually is currently, we do have part of 1124 adopted, but the only part that is adopted is the part on retail sales, not on storage. So part of this would also be our office adopting the rest of the standard that would then give us guidance and jurisdiction over consumer fireworks storage.
May I follow up, Madam Chair?
Yeah, go right ahead.
Thank you. Could you tell us some of the requirements that exist within the 1124? And then also I have in other bills I've worked on, we've had problems with referring to standards that exist outside of main statute because they update and they change over time. And so if you could just address whether this standard is ever updated or changed, because if that were the case, we would need to probably refer to a particular, because we don't just change our main statute based upon when other entities change their standard. It has to do with sovereignty of a state and that kind of thing. If you could just speak to that.
Exactly. Well, actually, Representative, none of our standards of the 55 we have adopted in our office, we specifically adopt them. What we do is we reference the overall standard and then the part that's put in there as adopted by our office, because we never want to give an outside agency the right to change a requirement without us seeing it first. So currently we have the 2006 version of the 1124, the chapter covering the retail sales. There is a section in that that covers storage of consumer fireworks. There is currently the 2017 version. There were a couple of versions where storage came out. There's been, this standard has kind of gone through some bumpy times where in 2012, it was actually repealed because of some, how can we say, industry concerns and things such as that. It is now back. And what it does is it gives us the ability, and it actually gives us true guidance on how you would store consumer fireworks. Currently, by rule, we have temporary storage, which is allowable behind a store if there is sufficient room for up to 90 days. So during the busy times, stores can actually put a what would be considered a class 4 magazine, which is a class 4 magazine, could be a Connex box, actually could be a trailer from a semi, could be considered a type 4 magazine. And those can be used behind a retail store. This is actually the reason this bill is here, is to give us capability for off-site storage for those that are not selling at that location and just storing fireworks.
Okay. And then just, could you give us some of the details of the requirements that exist? I mean, I guess you did just now in saying the class 4 magazine, but are there other requirements besides that?
There are requirements on the size of the structure. There's requirements on the construction type. There's requirements on clearances and things such as that. Of course, as fireworks, when you look at fireworks, consumer fireworks are actually a 1.4 designation, and that is a DOT designation for the type of firework that is, and that is a consumer firework. A display firework is a 1.3. The requirements to store those will be higher than a 1.4. And then if we go all the way to storage magazines, a 1.1 is high explosives. That's where we get to the highest level. So it's all based on the type of material stored. And as I said, this is a national standard. We currently have NFPA 495, which is the storage of explosives, which talks about that. A lot of 495 has actually been brought into 1124 for storage of consumer fireworks and display fireworks.
Thank you. Madam Chair, I have one final question, I promise.
Okay, go ahead.
Thank you.
No, this is very good. They're good questions. Go ahead.
Oh, thank you. And how did we come up with that idea of 60 feet from another permanent building that's in subparagraph in 4B there?
Actually, 60 feet is currently in statute. Statute says that a consumer retail fireworks store must be 60 feet from another building, or 300 feet from a building that is selling gasoline, propane, or any other flammable or combustible liquid. So that's already in statute. That is why it was pulled over.
Thank you.
Again, those are really good questions. Anyone else would you lower your hand also, Representative Booker? Anyone else wish to ask Mr. McCarthy a question, clarification? Seeing none, I will thank you. I have in my list, I don't have another one that's in favor. Anyone else wish to present testimony in favor of this bill? Seeing none, I will then go. Anyone wish to speak in opposition? And the first one I have here is Anthony Marson here, was first on the list. I don't see. Then I have Curtis Picard.
Senator, he's here. Mr. Marson is here.
He is, okay.
Yes.
Let me check here. Okay, I'm sorry, Ms. Marson, I had something up that blocked your face, so I didn't see you. Do you wish to provide testimony, Mr. Marson?
Yes, please. Thank you for having me today. I'm not necessarily opposed to this this legislative document. I have some questions and some concerns about the language as written. I'm more concerned about the fire marshal's office changing how much backstock essentially we can keep in our stores, our retail stores now, with adding in a provision to basically have a permitted storage facility either adjacent to the building or off-site. My concern, as I just said, is just basically striking storage and sale from line 6 of the first page of the LD. How much are we going to be able to continue to store inside the
Yeah,
sales
Mr.
building?
Marson, this, and forgive me for interrupting you, this process is for anyone to take what is written as proposed in the bill and offer testimony in favor or not based on your not only opinion, but experience. And if you own a business, if it negatively impacts your business, from there, in a couple of weeks, this same committee will have a work session and there'll be some adjustments to the bill and some discussion based on what we hear today. So I think it might be better for you to listen to the other testimony, and please submit anything to us in the committee in writing. And we may ask those same questions when we get together. Is that all right with you?
That sounds fine.
Okay, good. I do have Curtis Picard, who was against. Did you submit testimony, Mr. Picard? Is he here? All right, I don't see him. And forgive us if this sounds a little quirky. We're trying to tighten up the whole process. We usually get the testimonies available to us. So I've seen Daniel, is it Pert or Pearl? Pert. Dan, do you wish to present
Senator?
testimony? Yes.
Senator, Mr. Picard is here. I don't see him, but I just received a note from him through the chat.
Oh. Well.
Sorry about that. I'm letting him in.
Okay, thank you.
Thank you.
Hello,
There we
Mr.
go.
Picard.
Good morning, Senator Deschambault.
Yes, if you've been hearing this, this is testimony in opposition to the proposed bill. Do you wish to provide testimony?
I do wish to provide testimony, but I think it's neither for nor against, so I'm happy to wait.
Good,
If that's
thank
your
you.
preference.
Yep. I have your name. I don't have why. Okay, thank you for that. Let's skip Mr. Picard for now, and I'm up to Daniel Pert.
Thank you, Madam Chair. For clarity, I thought I registered as neither for nor against,
Okay.
so I'm happy to go now or wait until your
Nope.
direction.
I have to do it. I will go with everybody who wrote in against. Okay, thank you. We'll get back to you. Deborah Hart from the Retail Association of Maine. I have that testimony. The position is against. Is Ms. Hart here?
Senator, Ms. Hart is my contract lobbyist, and we registered both of us in case we needed to tag team separate committees.
Okay,
So you can scratch her off your list.
thank you. Isn't this a lot of fun, huh? Okay, great. As long as we all understand here. I have Katie Bryant of Wiscasset who may want to speak in opposition. I see you and Tom. Welcome. And you may provide your testimony. Can you look at your laptop or computer and unmute yourself, okay?
We may not be strictly against it if it could have certain amendments. So I don't know how that will affect.
Well, why don't you, it sounds, Representative Warren, if I'm correct, it sounds like you're not totally against it, but you would like to propose some changes. So go right ahead and let us know what those are. Have you submitted something in writing, Ms. Bryant?
Yes.
Okay, good. So we have that, right?
Yes.
All right. Go right ahead and tell us what your concerns are and your proposed amendments.
Okay. I'm Katie Bryant of Wiscasset, and I appreciate the opportunity to testify. I'm deeply concerned that LD 180 doesn't adequately protect the safety of homeowners, innocent homeowners. We happen to live next door to a consumer fireworks warehouse. LD 180 would allow a large warehouse storing tons of explosives with no sprinkler system to exist as little as 60 feet from a home. How many of you would feel safe living in a home that close? The 60-foot separation distance stated on page 1 of LD 180 is woefully inadequate. Stores selling consumer fireworks generally have sprinkler systems, but a warehouse as large as 12,000 square feet isn't required to have one. Thus, the setback needs to be much more than 60 feet. Our summary statement explains about prior law using a figure of 1,000 feet, and we urge you to read that and incorporate it. Logically, the law should prohibit fireworks storage in a residential area, right? Well, there is a provision in NFPA 1124, Chapter 6, with that exact prohibition. It's 6.2.4. And I'm just needed to jump back to what Rich McCarthy was talking about on the addition. I don't know why we would want to use 2006 when 2013 is more current and has more safety features. Anyway, the real stumbling block, and this is critical, is that NFPA 1124 doesn't define what a residential area is. In our situation, certain officials chose to equate the term residential area with the term residential zone, despite the fact that at no point anywhere does NFPA 1124 use the word zone. The interpretation hurt us because being in a rural zone, the prohibition was ignored. But you can have a rural zone with heavy residential use, and it's the use that matters. In our case, there are many homes surrounding the warehouse, including an actual mobile home park just across the street. I should add that in our litigation over the matter, the residential area issue was never adjudicated. Anyway, residential areas should not be equated with zone. Some Maine towns don't even have zoning. So we implore you to give weight to our request to have LD 180 specifically prohibit fireworks storage in residential areas. And then it's imperative to go on and define residential area in terms that leave no argument, terms with objective criteria. Our summary comments offered some wording on that definition. Please incorporate this or something similar into LD 180 to give some protection to innocent Maine homeowners. Thank you for listening. Any questions?
Representative Kluka.
Thank you for your testimony. Thank you, Madam Chair. How far is your home from the storage facility?
It's about, we have a garage, it's about 300 feet or so.
Yes, it's about 300 feet to our garage and another 300 feet, another couple hundred feet to the house.
If I could follow up, Madam Chair.
Go right ahead.
And does your insurance company require you to be a certain distance from a fireworks storage unit in order to insure you?
Well,
and what is the number? And what is the number that they require? Thank you.
We're scared to death to bring the subject up to them because we can see our rates going through the ceiling, or we can see ourselves being canceled. And this has happened to a neighbor of the the fireworks outlet up on Route 1. So that's all I can answer on that.
Thank you.
That's Representative Pluker, you all set? Okay, thank you. No other questions. Thank you both, Mr. and Mrs. Bryan, for your testimony. We'll take that in consideration. Oh, okay. Oh, do you wish to speak, Mr. Bryan?
Yes.
Okay.
Is it my turn?
Yeah.
Okay, 3 minutes doesn't begin to let me cover what the ground that I'd like to cover, but so I'll have to keep it kind of short. One of the problems with LD 180 as drafted is that it appears to be I'm sorry. What I'd like to talk to you about today is what is a highway or a public highway, and how much setback there should be from a consumer fireworks storage building to a public highway. I hope you have all had a chance to read the document that I uploaded titled Consumer Fireworks LD 180 Historical Information on Highways. That document describes how the NFPA's definition of highway has evolved over the years. Over time, that definition has evolved to be ever more inclusive and therefore more protective of roads and highways that are open to and traveled by the general public. This inclusive definition of highway is necessary to protect people traveling past a fireworks warehouse. It doesn't matter how few in number those travelers might be. Every single person who travels past a fireworks warehouse is deserving of protection from the dangers that warehouse poses. That protection can only be provided by reasonable setback requirements, such as provided by NFPA 1124, Chapter 4, or NFPA 495, Chapter 9. For example, the minimum setback requirement from any highway, no matter how small the traffic volume provided by NFPA Table 495, Table 9.4.1 for an unbarricaded warehouse containing up to 3 kilograms, which is about 6.6 pounds of explosives, is a bit over 63 feet. The required setback goes upward from there, becoming as large as 2,000 feet, depending on the weight of the explosives stored. For example, the minimum highway setback requirement in NFPA 1124, Table 4.6.6, starts at 35 feet for anything under 1 ton, half ton of fireworks. That required distance increases rapidly with weight, reaching 100 feet for anything over 50 tons of consumer fireworks, an amount easily stored in a 12,000 square foot warehouse, the size under which a sprinkler system is not required. The minimum setback requirement from NFPA 1124, Table 4.6.6 is actually greater than 60 feet separation from a house that is proposed by LD 180. However, if you look at the standards, they do not provide for any setback from a highway. We need to get requirements for setback from highways into the law. This is a glaring omission that the legislature should rectify for the protection of the general public. Such protection becomes doubly important for a dead-end road like JB's Way, where there is no other means of access or egress in an emergency. Thank you.
Thank you, Mr. Bryan. Yes, you bring up something that's really not in this bill, but I'm sure we're going to discuss it and see if it's impacted in another area of the statute. So thank you for that testimony. Seeing none of questions or hands raised right now, we'll go on. Let me think here. Tom Bryant.
That was me.
Oh, excuse
I'm
me.
happy to read the rest of my statement.
You know what? I was just, they didn't put you with Katie. Okay, I gotcha. Thank you. Anyone else wish to speak in opposition to this bill?
Madam Chair,
Mr.
my name's John Potter. I'm not sure, I may have signed up as in the neutral, neither for nor against. I'm the attorney that was involved in the case and represent Tom and Katie Bryant. So I'm happy to go now, or I can wait until you get to that segment.
You may as well, if you make reference to what they were talking about, go right ahead.
Yeah, I think that would be logical if that's the pleasure of the committee. So as I just mentioned, my honorable members of the committee, good morning. My name is Jonathan Pottle. I'm a resident of Bangor. As I just mentioned, I represent Tom and Katie Bryant. I was involved in the specific case that was referred to by Mr. McCarthy. I would have a slightly different view of that. I think the judge said it wasn't a directive for the legislature to say, go and allow storage buildings to be authorized. That case said that that facility that Tom and Katie are referring to required a retail license because consumer fireworks are there stored there with an intent to sell. It's pretty clear they can't meet the standards, which is why you have, in my mind, LD 180 before you. As written, LD 180 is not sufficiently protective of residents of the public from storage consumer fireworks. It's because it doesn't have specific setbacks and it refers to codes that don't clearly address that issue. It's not clear which ones will be adopted by the Department of Public Safety. There's some potentially varying conflicting provisions. And as mentioned, some of those provisions have been removed. If you look at Chapter 6 and Chapter 7, they used to be there under storage and retail. They were removed via March 2014 decision by the Standards Council. As mentioned by Mr. McCarthy, certain provisions were put into a different chapter, still has the same prohibition on residential area. But I mentioned, if you look at magazine, that's mentioned in LD 180. If consumer fireworks are stored in a magazine, take it at 2,000 pounds, that's 1 ton. That's just over 1,000-foot setback to the nearest inhabited building. That's what the code NFPA 495 states. LD 180 of 60 feet from any permanent building is wholly inadequate. It needs to have specific language specific to residences to have that level of protection. Going back to NFPA 1124, residential area, it still says it's prohibited in a residential area. It should matter what is actually there on the ground. If you look at the Bryant situation, there's 40 or 50 residences that are up and down and surrounding this facility. That is a residential area, no matter what label you put on the zoning. It doesn't matter. It should matter what the actual use is. It's very clear. The solution is very simple here. Legislature, you're very able to put in specific requirements. The Bryants have submitted potential amendment language to give those specific setback requirements and prohibitions, both for residences as well as roads traveled by the public. I urge you to review that language and incorporate that into any updated LD 180 so you can sufficiently protect residences like the Bryants and their neighbors. Thank you.
I'm going to ask a clarification, Mr. Pottle. It doesn't sound like did you submit written testimony of, you have?
I have. It should be, I got an email that said it was submitted and distributed.
Thank you.
So I think it's in there.
Good. Thank you very much. Anyone else wish to speak in opposition? I'm then going to go to neither for nor against. Seeing none, I will go to Curtis Pickard.
Good morning, Senator Deschambault, Representative Warren, and members of the Criminal Justice Committee. My name is Curtis Pickard, and I'm President and CEO of the Retail Association of Maine, here to testify neither for nor against on LD 180. I'm not often in front of this committee, so I appreciate the opportunity to talk about an issue that impacts retailers. Our members are retailers of all shapes and sizes, including folks like Phantom Fireworks, who is a retailer of fireworks down in Scarborough and other locations in Maine. I honestly really wanted to listen to the whole discussion of today because I understand there's been some discussions behind the scenes, or not behind the scenes, with the interested parties on some amendments. As I understand it, retail fireworks sellers sometimes use containers and temporary storage units, and that's not explicit in this bill. So I believe Mr. Pert is going to talk more about some potential amendments to that. So we just wanted to be on record representing retailers. We're happy to work with interested parties on whatever amendments come forward and offer input where and when we can. Thank you.
Thank you, Mr. Picard. Any questions for Mr. Picard? I think he made himself understood. Very good. I now will turn it over to Dan Pert. Dan?
Thank you, Madam Chair. Good morning, Chairwomen DeChambeau and Warren, members of the committee. I'm Daniel Peart, Director of Government Affairs for Phantom Fireworks, the nation's leading retailer of consumer fireworks. Phantom has operated for 45 years in all but one state in the country and has made a home in Maine since 2012 when consumer fireworks were first legalized. Thank you for today's opportunity to testify on House Proposal 133. We understand the mandate from the court that led to this introduction, and we understand the intent of the bill is to formalize the licensing protocol for the storage of consumer fireworks that those of us who operate in Maine already understood to be in place. While I did register as neither for nor against HB 133, we see no issues with either the mandate nor the intent, but we'd like to discuss a potential issue in the crafting of the language and propose a solution for the committee's consideration. The language in HB 133 seems to suggest that consumer fireworks storage can only be licensed in a fixed permanent building or a magazine. Since fireworks have been legal in Maine, to use and sell temporary storage solutions such as shipping containers or semi-trailers have also been permitted to be used. Similarly, containers and trailers are permitted for the storage of consumer fireworks in NFPA 1124, a consumer fireworks specific code that Maine has at least partially adopted or incorporated in its enabling legislation. Further, a magazine as defined in NFPA 495 is seldom used, if ever, for the retail storage of consumer fireworks. In any state where Phantom operates are 80 permanent locations and more than 2,000 temporary locations. Magazines are not required, nor are they used. Put simply, a magazine is a temporary storage solution for commodities that are significantly more energetic than consumer fireworks, such as professional display fireworks or bulk hazardous materials. In the interest of fairness, I reached out to the State Fire Marshal's office this week and explained our concerns and was quickly reassured that eliminating the use of containers or semi-trailers for the temporary storage of consumer fireworks was not intended, and they would be receptive to language that would clarify as much. I have forwarded these suggestions on to Mr. Richard McCarthy, who testified earlier, at the State Fire Marshal's office for his review, and I will include these suggestions below. With the inclusion of these amendments, Phantom Fireworks would be supportive of HB 133. Thank you very much for your time, and I'm happy to answer any questions.
Thank you. Anyone have any questions of Mr. Pert? That information was helpful, Mr. Pert. We'll talk with Mr. McCarthy, I'm sure. He'll be submitting something. Anyone else wish to speak neither for nor against? Seeing none, I call this hearing to a close. I believe, Ms. Orbiton, is it next week or the following week? We're going to have a work session. I think there's a lot of work that has to be done with this one. I'm going to be ready next week.
It's currently on the schedule for next week, the 17th at 10 a.m.
Yeah. All right, we'll leave it as is, and I'll talk to my co-chair afterwards. And a lot of technicalities, we want to get it right. So, all right then. So this concludes what we had on the agenda for today. Again, the work sessions will be next Wednesday schedule, and we will be doing work on what we heard on Monday and today. Representative Warren, do you wish to make any comment or suggestion on what we might have to do next?
The only thing we have next is just a committee meeting regarding our committee rules.
Mm-hmm. Yeah, are you prepared, or should we discuss that now?
Could we close the public hearing so that folks may be excused and we can just focus on our committee work?
I think you've spoken, and that sounds good. So
thank you, everyone.
We will be going into a session just to discuss our committee rules. So again, I want to thank everybody that from the public that came this morning. And so again, I close the official meeting right now. Thank you.
You guys all get an email with that, with the rules.
Jane, did you have a chance to send those out yet?
I sent them to Representative Pickett and Senator Searway.
Okay.
Okay.
Madam Chair?
Yes.
Okay.
Yes, this is Representative Pickett. I have them, I received them just a few moments ago. Could we have maybe like about 10 minutes so that I can go over what I have, because the rest of my committee does not have them. And these are committee rules that we should be talking about as a full committee. I assume that's what we're going to be doing right now. So if we could have a 10-minute break just so I can go over that with my people, and where I'm the only one that has them.
That's a good idea. And Jane, could you send them to everyone, and then everyone will have a copy before and I think it's a good idea to take a break and expect folks. I'll give a couple people a call so we can chat as well.
All right.
Representative Warren?
Yeah.
Just to clarify, do you want to stay in this meeting?
I don't think so. That's a webinar for public hearing, right?
Yes,
Or
and so
will
it's
that
on
make it-
YouTube. It will continue on YouTube.
No.
I don't think people are interested in our committee rules. Yeah, let's go to our still public, but it's the work session mode. Will you guide us, Deb?
Yes, we will be in a meeting. It will not be public though. So once we go off YouTube, we're off for the day.
Jane, how do people usually do their rules? I don't want to run afoul of any proper procedure here.
Well, are you asking, do they have to be done in a public meeting, or do they have to be done broadcast?
Yes.
I think the answer is yes.
I think so too. Yeah. So let's take yes, Deb, please.
LIO, Casey and LIO didn't seem to think so. I can call and double check. But I told her that we might be going to a meeting that would not be on YouTube, and she seemed to think that was fine. So I guess we need to check.
I don't think we should probably ever do things that are not public. makes me a little bit nervous. So let's not worry about that. People can hear us talk about our rules. It's going to include our rules on eating and etc. So let's not worry about that. How about we take so it's noon now. Could we come back at 12:15 and do our rules discussion? Senator, does that feel okay to you?
I don't even know what time it is.
It's almost
yes.
noon.
Yeah. 12:15. All set there, Mr. Pickup?
Yeah, sounds good.
Good. All right. So let's say we're on a break till 12:15.
Thank you.
Thanks.
I just sent the rules through. If anybody didn't get them, will you let me know?
Thank you, Jane.
Thank you.
cheapest things in the world.
She's talking with somebody else. She's not talking with us.
Hello, people. We were having a conversation, a group phone call. So that's where we met.
I just thought you had money in the bank because you were talking to yourself.
Oh. Yep. I don't know about you guys, but this was a very busy weekend for me, and I'm sure anybody who tries to keep up. The Veterans and Legal Affairs have maybe 3 times more bills, and with each bill, there's like 5 testimonies and more. So, it's difficult. All right, are we all here?
Aye.
Or as the coach used to say, whoever's not here, please raise your hand. So.
I think Representative Costain.
Yeah, he's here.
Oh, he's okay. Great.
I think
Okay.
he's still in the same zip code.
Representative Warren, do you feel okay if I turn that over to you and you go step by step and we'll either have discussion on each or vote on each or vote as a whole on the rules?
Okay.
Senator?
Yes, Representative Pickett.
Yeah, I mean, I can wait until after or I can go before, but there's one thing that's not on here that I noticed that I know that we spoke about it when we did our meeting earlier, you and myself and Chair Warren, and that I want to address too. So I mean, I don't know if you want me to address that first or you want to go through these and then save that for last. Either way, just as long as I have a chance to do that.
Let's go with what we have. And yes, please. And then it's something, we added something too that was missing. So it might be the same. So let's move on.
Okay. Yep. Sounds good.
Thank you. So Representative Warren.
Okay, so just so new members know, there are sort of a standard set of committee rules that are, across the board. And it's normal practice for each committee to then make changes of their new session and their own rules. And that's what we're doing here. So you can see the first one, consumption of beverages by members is allowed on video and in committee room. No consumption of food in the committee room. Members consuming food while attending remotely will turn the video off. And when we get through COVID, right, and we're all back in there together, obviously we as a committee have allowed eating in our room because we have to sometimes work through lunchtime. Sometimes we're there, later, and we'll just say, let's all run and get our lunch and just eat and continue our work. That will still be our process. But when you're together in a room, eating requires taking off your mask for an extended period of time, which puts other people at risk. So we're just asking that if you are eating, to just step out of the committee room. And if you are eating when you're on the video that you just shut your camera off, you know, so that we're not sort of eating during a, you know, a meeting in front of our folks that are joining us. So that's the thinking around that one. Obviously, beverages in the committee room, fine. Beverages on video, fine. Written communication, I'm on the next one. Written communications from the
Why
public.
don't, do you want to ask if everybody's
Sure.
in favor of that? Or if we did, okay? Or
Good, everyone good on that? First one? Okay, great. Okay. Written communications from the public to members must be directed through the clerk. That's the same as always, right? If someone were to come in your committee room, they're not allowed to come up to you. They would go to Deb and pass a note and, you know, to her, and she would bring it to one of you. So that will remain the same when we're back together. Everyone understand that one?
Yep.
Okay. The third, sponsor and other legislators speaking in favor of the bill may question other persons who testify only with the permission of the chair. This, I think, is also just a politeness issue. So let's say that Representative Morales presented her bill. It's just sort of shared practice that then she would not be questioning the testifiers that came after her. She'll have that opportunity to discuss during the work session. If she felt like something was really being misunderstood or she wanted to clarify something, she might say, I would like to ask, and she would do this publicly, I would like to ask permission of the chairs, and I think we usually say end of the committee, you know, like we're doing it publicly, to ask this question. So let's try to not do that if we can, but like I said, if there's a real misunderstanding, you might need to do that, and it's important to do that publicly. Questions or concerns about that one?
I want to give an example that happened the first time I was there. So let's say I present a bill and I want to change something drastically. And then an hour later, people testifying against make a comment. I think I may have done this the first time, but it's happened. And I wanted to challenge what someone said in opposition, especially, and we're not talking legislators, the public. That's the reason we have that rule. You are a legislator, and it's very intimidating for the public, for the legislator to ask to be even more clarifying. So that's basically, unless it's really out of the ballpark and you've got to have that person clarify a comment or a statement. But think how frightening it is for some people in the community to testify and the sponsor is questioning them. So that's pretty much it. Okay. Thank you.
Everyone good on that one? Okay. During COVID restrictions, this is actually something that is also the rule non-COVID, but what's added here is over Zoom. So we aren't allowed to use props or signs or posters. You know, if someone just came to testify during our last public hearing and was wearing a face mask that said, I hate fireworks, right? That's a prop and it's not allowed. T-shirts with comments about the bills, not allowed. Signs, right? We shouldn't have signs, you know, we shouldn't come to testify with a big poster behind us, right? But also no screen sharing, that's also a prop, right? Screen sharing is done for informational purposes. I suspect Jane, when she's doing our bill analysis for us, will screen share as we're doing work sessions, but we are not allowed to do that as part of our testimony, or, you know, props are not allowed. Questions about that one? Everyone's good?
Most of the time, it would be if I'm watching and someone's testifying from home, and we have something on the screen that has nothing to do with the bill, but is offensive to a lot of people. In other words, you wouldn't come in to the meeting with, you know, an Israeli flag or something. Why are you carrying that, or a Confederate flag, or what have you? So it's their home has to be as if they're coming in also, and not to make a statement.
Okay. The next one is the use of chat function over Zoom should be limited only to non-substantive messages such as scheduling. That's just any questions that we're asking of anyone that's testifying in front of us needs to be public. And so the chat is not to the folks that are participating. So we need to be asking those questions publicly, and any departments that are giving us information, we've asked them to not just give Representative Pickett the answer after, but to give that to the whole committee. To make the assumption that if Representative Pickett has asked a question, that's a question that the entire committee wants the answer to. So just being really careful about, you know, how often we use that chat function.
Mm-hmm.
Everyone good?
Yep.
Great. Member use of the committee room is limited to scheduled committee meetings and 10 minutes before or after. And that's just trying to reduce the use of that room for the clerk's purposes also. No non-members obviously would be in the room, and, you know, to please not be there 10 minutes before or after 10 minutes after. Those are the times when Deb would be preparing for a meeting or, you know, fixing up the room after a meeting. Questions about that one?
That would just be during the COVID, while we're in the COVID restrictions.
Yes, that's all. Thank you for clarifying. Yep, that's it. Is just during COVID. Okay. And then just the thing that we talked about yesterday quickly, but we should make sure is in our rules, is just the very clear difference between the time of a public hearing versus the time of a work session. We all will make this mistake, and we'll get reminded. Senator DeChambeau and I will even remind each other that really during a public hearing, our role is to be listening. And I know you, Representative Newman, you serve on a select board, right? And so it's really easy when you've done municipal work to know what a public hearing is about. Well, sometimes in the legislature, we forget, and it can very quickly turn into a work session. I have to tell you that during these COVID times, sitting on this Zoom is not fun for any of us. I do not like it, and I suspect no one else does either. So I am going to have unbelievably limited patience for the sort of going into a work session when we should be in a public hearing, just using our ears and asking questions specifically for people to clarify. I'm not interested in your stories. I don't want to hear them. If we're having our work session and the banter is helpful to us as we do our work together, that's one thing. But let's cut down on the stories and the sort of back and forth during a public hearing. I think additionally, when you're preparing to ask a question during a public hearing, try not to give your complete autobiography, right? We don't, you know, we're not interested during a public hearing, and the people that are there to testify, they're not interested either. They're there for a purpose, which is to share their thoughts on a bill. And our job is to take their thoughts. So please just ask your question. You don't have to preface it. That's it for me. How about you, Richard? What you got?
Yeah, that was very well said on the last issue, because
Yeah, my patients are already thin.
Well, that can, and I can just imagine one of these meetings that we have, or public hearings that we have, when we have 50, 60, 100 people in there. I mean, that was very well done. What I had was what you and Senator DeChambeau and I talked about when we talked about committee orientation and setup, and that first meeting we had, a Zoom meeting. And that is that I know it's a different world out here right now. I know that we're in a virtual situation and stuff, but we talked about this, and I think when we go to work, and we are working, whether we're working from home or whether we're working sitting in the State House, either way, we're going to work, we're working at home. And I know we talked about this, and I really think that we should be wearing the attire that we would wear if we were here sitting in the committee room. I think that's only polite, and also it's respectful. And it is a public hearing, so there's many people on the outside, the public, that's looking and stuff, and it helps us to keep and maintain a professionalism about what we do here. So I know we talked about that, and I think I'm not going to speak for either one of you, but I think we all agreed on that day about that. So if you want to add anything to that, Senator DeChambeau or Representative Warren, that'd be fine. But I really think that should be something we should really be enforcing.
Mm-hmm. I agree with you 100%, and I forgot we did discuss that, and we've also discussed it in chairs and leads, etc., that as committee members, it is just very important for us to welcome the public to our committee room in exactly the same way we would do if we were all sitting in the room, which means, looking professional, being professional. We all are representing ourselves as a team, and we are a team. And so I think I totally agree with you. I think it's very important. I'm not going to say that I don't have yoga pants on right now, but I'm wearing a nice sweater and a blouse.
That's all that counts.
Questions about that? Does that make sense? Okay.
Representative Blucher?
Thank you. I came from 12 years of Catholic school, so dress uniforms can be important to me. Are we going to put some rules around what the uniform is, or is it just kind of up to the interpretation of the chairs, or how are we going to go forward with that?
There are rules, aren't there?
Wouldn't it be as if you were here in the building and you were going to your committee room to a public hearing, you'd dress appropriate to go to the public hearing. I mean, which for men, I think would probably be a shirt and a tie and maybe even a suit coat. I don't know, but dressing appropriate.
I don't think it's a shirt and a tie. So that is the rule for when you are in chamber. So when we go into chamber, absolutely, I have to wear a jacket. I wouldn't wear a sweater. And that is also the rule for you guys, is a jacket and a tie. But during committee meetings, it's what's referred to as
business casual.
Business attire.
Yes. So that includes sweater, exactly what you're wearing, Bill, exactly what you're wearing, Grayson, right? A button-down shirt. You guys have suits on. Victoria has some sort of sweater. I have a sweater. This is all fine. I think what we don't want to do is be wearing like t-shirts or tank tops, or, sweatshirts, I guess. Does that make sense? Again, there's no rule on yoga pants or dress pants.
Or no pants. I don't know.
I wasn't going to go there, but you did.
Thank you.
Look, it brought a smile. You've all thought of it. No.
Anything else that we're forgetting, you guys, or anything you want clarifying, and we'll all do our best and we'll help each other, you know. Yeah, Bill.
I think you answered my question already. So we don't have to wear a jacket if we're in committee room.
No.
No.
I was thinking though that for the new members, you know, this is not the way to have a meeting. You all know that. I'm looking at Representative Costain and Pickett, and we're all missing each other's cookies and brownies and donuts.
Sandwiches.
And, you know, before the meeting or after. So I can't wait to get back. I mean, I've made a lot of peanut brittle and everything, and I'll mail some to you, Dan. I can't mail it to you.
We got plenty of room in the committee room. You're more than welcome.
All right. So,
and I think that can I say two more things? Sorry, I wrote them down and I forgot to say them.
Go ahead, of course.
Thank you. I did start today off with them, and I just want to make sure that for folks who maybe weren't here when I said them, we will have a better system before our next public hearing. So next week, we don't have any public hearings. Monday's a holiday, so we won't be together. Wednesday, we have work session. The following week, we have more public hearings. By then, we will have a system. I have been, I think, assured by IT, whereby when testimony comes in, it will be automatically loaded onto the committee materials section of our committee website so that we can go there, print it all off if we want, read it all there if we want. I agree that it is absolutely unsustainable to have all of this come to our email. I do not have time to organize it all. I'm completely disorganized right now, which is really driving me crazy. So that will be taken care of by our next.
Charlotte, I have a question.
Yes.
If IT said that to you, that's going to apply to all the committees?
Yes.
That will be doing that? Good.
Yes.
Thank
Yes. Yeah. I mean, I basically am like, if they can't figure out how to make it work, I'll come up and help code it, you know, because it's not that hard to put things on the website automatically. I think that it's just, anyway, we don't have to go into it. That's boring. That was one of the things. What was the other thing? Wasn't there something else we've been struggling with? Email? I can't remember. There was something else. Oh,
Charlotte.
Zoom links to your personal email. So there's a rule for Deb or any clerk to not share committee stuff to your personal email because of freedom of information, etc., which I totally agree with. But she should be able to share a link to Zoom so that we all get an invitation to our calendar in whatever form we need it to make this easier. So that will hopefully be fixed as well ASAP. That was the second one.
Good.
I do have a question for you.
Yeah.
When it comes to that, when we're all in the building, obviously and stuff, the clerk sees to it that we have the testimony, it's all printed out and stuff, and it's laying on our desk and ready for us and stuff like that. Is whether our committee members that are here and in the building, and so what is prohibiting the committee clerk to have that stuff ready and available for those that are here attending each day, rather than us having to print it ourselves and that kind of stuff like that? I don't know if there's been talks in other places about that or whatever, but that would be very helpful to those of us that are here to have them here and available to us, like we would because we've chosen to address this as we're here in the committee every day as though we were having normal committee meetings and stuff. And you know, if we don't show up before 10 minutes before and we don't hang around afterwards and do all of those things, what is prohibiting the clerk from doing that and having that available?
The directors have met and they have directed the clerks to not print anything. Let me just give you some information about that. It's been set up so that our partisan offices, House Democratic office, House Republican office, et cetera, will make print and House Independent office, Bill, and Senate Demo, you know, every partisan or independent office will make available to the members the ability to print in there, that it's not happening through the clerk. And in fact, even if the clerk wanted to, he or she is disallowed right now from doing that. At Legislative Council last Thursday, there was quite an in-depth, I think it was last Thursday, maybe it was the Thursday before, but there was quite an in-depth discussion about this. And Speaker Fectow did make a promise that they would be revisiting that topic. It was brought up by Senator Timberlake, and there was a lot of discussion. So I suspect we'll hear more about that part. But for right now, because the clerks are responsible for making sure that everybody that may contact them 5 minutes before a public hearing and want to testify, they're trying to figure out how to make sure everybody has a link, who's in the waiting room, who's coming in, getting the information to all of you, answering the phone for people who want to learn how to testify. You know, they're sort of the gatekeeper for all of us right now. And so directors have asked that they do not print or do anything like that. They try to facilitate all of the Zoom as their first priority. And as I said, that conversation may be revisited by Legislative Council, but at this point, it's not a decision of Deb or your other clerk in your other committee room. It's a decision by their supervisors, the Legislative Council and the directors, that at this point, if you need to print, you'll do it in your partisan or nonpartisan office. Did that answer the question?
Yes, thank you.
I know this is a tough thing to get used to, and I agree. I can't even tell you what a mess it is here. So, Jane, did you have a?
Yes, thank you. I just want to remind people, Monday is holiday. Wednesday, you have work sessions on the bills from this week at 10 in the morning. At 1 in the afternoon is a meeting of the MIAC Advisory Committee. And you all have been invited to attend that meeting if you want. That is the main information and analysis center within the Department of the State Police. Does anybody need or want a new copy of the invitation from the state trooper who sent it to us?
Yes, I would like one, Jane. Representative Pickett, I would like one.
Jane, could you have Deb send that out to all of us as
Sure,
an
I'll
invite?
just send it to everybody.
Can you send it as an invite to our calendar?
Oh, I'll send it to Deb.
Yeah, that's the part that I think the part that's hard is we have multiple meetings. I mean, this morning I had chairs, then I had caucus, then I have this. For me to try to keep track of Zoom links in emails, it's not sustainable. I need a calendar invitation. Okay. And I think that those calendar invitations, again, we're trying to get that information propagated to Casey.
Sure.
I need that to my, email. So
I'll get Deb, who's got her hand up. I'll get Deb to help me, but I don't think we have that invitation yet from the state police. Okay, they sent us a notice about the meeting.
Right, but not the Zoom. You're right. We don't have that yet. Yeah, great.
Deb, did you want to help with that?
Yeah, just to clarify, I can send you calendar invites to the meetings we do that we schedule, and I can send you, when you get the invitation as a panelist for a public hearing, it has those links to the calendar that you can do yourself. But if it's coming from somebody else, I don't think we can do that. They have to.
I do have the Zoom. I can send it to someone. It was sent to us on the email in January. So let me,
Okay.
I'll send it to Deb anyways. And if I'm correct, you can send it to them. Okay.
So Deb, if you have an invitation from someone else, like AFA, let's say, because we're going to have a public hearing soon around the budget, can you then forward that to our distribution list, which includes, some of us have both emails, personal and legislative?
Yes, but it doesn't mean the calendar functionality is there.
Right.
It's something that
Got it.
comes from the person who's, or the body who's inviting you.
Right. Some we'll have to do manually.
Right.
But if most of them, we get a calendar link, boy, that will help so much. Okay. Representative Costain.
Yes, Representative Warren, thank you. So, of course, I use Google and Google Docs and everything in Google. So how do I use this Outlook, the calendar in Outlook? Is that something, if I called you, you could explain to me?
I definitely could, but also IT can. So it's kind of convoluted. I'm sort of one of the people that are grandfathered by having everything forwarded, which I didn't realize they've stopped doing now. They've stopped allowing you to have things forwarded from that Outlook system to Gmail. I did talk to Nick yesterday, that's IT, and he assured me that I would be able to add the legislative email to my system here for processing email. So you're saying that you sign into a web-based Google service to get your Gmail, right? You don't have a program like Outlook or something else that processes your email.
No, I use Google for everything. So my email, docs, sheets, everything, I use Google. So what happens is when I get it on my legislative email, I have to manually take everything and like if I have hearings coming up and all that, I have to manually put it over into Gmail because the two don't work together.
I think he can help you with that. I do. I think if you call the IT help desk, they can help you get those two systems to talk to each other. Or if you're just using a web-based platform anyway for Google, you could just do the same thing for the Express, Outlook Express now. Does that make sense?
Charlotte, is it easy for him to just talk about the Google app, Google Calendar app, and you can put your wife's birthday on there, or you've got a dentist appointment? It's not just
that's what that's what I use. I use the Google Calendar and everything I use all the time. But that's what I'm saying. But this stuff comes in on Outlook and you can't put it over there unless I'm missing something.
You've got to do it manually.
Yeah.
I do it.
I'd call IT because he assured me yesterday that that application, which when they first started using it was terrible, which is why I had it all forwarded. He said that it's made vast improvements. So I would call IT help desk and see if they can hook you up. I need to do the same thing. You want me to go ahead and do it and then I'll try to explain it to you? I'm happy to do that, Dan. Let me try today and then I'll give you a call if I figure it out, okay?
All right, great. Thank you.
All right.
And then I saw Jane and Representative Lookner.
Yeah, I just wanted to clarify what you want your criminal justice rules that you have just, I think by acclamation, agreed to submit. Those go to the presiding officers for approval from them or disapproval sometimes of certain aspects. So what I do is I take the model rules and I annotate them at the end with changes that you're proposing.
Yep.
So it seems like the 6 that we started with and that were written down, I think I'm clear that you want those inserted into those rules as the proposal from the Criminal Justice Committee. The last 2 you talked about, one was the sort of trying to be brief in asking questions and not making public hearings into work sessions. Do you want that as part of your rules, or do you want that as just sort of your understanding of how you plan to operate?
I
Do you
think
see
the
what I mean?
second. I don't think it needs to be in the rules. What do you guys think?
Yep.
Okay.
And then the same question with regard to professional attire and demeanor. Do you want that in your rules, or do you want it as your side agreement?
That seems like more of a rule that it should be in there, I think. What do you guys think?
No,
You agree?
I think we all had an understanding that there is the presiding officers and there is a joint rule about attire in the chambers. And like you said, you got to wear a jacket, and there was a time the woman couldn't be sleeveless or what have you. But an understanding for the hearing to just be especially properly attired. When we're back in the State House, the men will probably all wear their jackets anyways and ties, but here.
Yeah, it'll be July, Senator. They'll have permission to take their jackets off.
I know, in July, thank you.
Okay, so the one about being succinct in your questions, we'll leave that out. And the professional attire we'll put in.
Great. I think that sounds good.
Okay.
Representative Lookner and then Representative Fluker.
Yeah, I just kind of want to second what Representative Costain was saying. I tend to use Google for pretty much everything, and it's just been, I'm having to learn this whole Outlook system, and I'm finding it, clunky and a little bit antiquated. And I talked to my aide about it, and it's just obviously the, state of Maine legislature isn't, Silicon Valley or anything. So I'm
not even close.
It would be super helpful for me to be able to get invites in a Google Calendar form, because it does take a little bit of time, and just having multiple tabs open and just, copying and pasting, and
yeah,
it's a little bit of effort. So I don't know if there is some way to put in a plug to get Google Calendar invites sent to our legislative email.
Let me talk to Nick today. I think using the example of it's not Silicon Valley, I think it's Kennebec Valley, so it's a wicked struggle. And let me ask that question as well, Grayson, okay? Bill.
I was just going to throw out this conversation around questioning during public hearings is covered in the model committee rules 7E. That talks about argumentative, oppressive, repetitive, or unnecessarily embarrassing questions, and advocacy and discussion among members is not appropriate in public hearings.
Perfect. Perfect. Thank you. All right.
Okay.
Lois, do you have a question? You're on mute.
Yeah, just a quick question. Mostly because I was the one that had an apoplexy when I discovered this rule after I had violated for 3 or 4 weeks when I first got to the legislature. The changes that got made today by us about our committee rules, tell me what the dress code is.
Business casual in committee.
Okay.
No t-shirts, no sweatshirts, no tank tops, that sort of business.
All right.
Business casual.
Okay. And you couldn't tell if I had jeans on because you'll never see my legs. So
Right, there you go. There you go.
however, I
Anyone
did start
else?
yesterday.
Oh, go ahead.
No, it's fine.
Everyone else good on that whole thing? I've added to my task list reaching out to IT and seeing if we can try to get some of this figured out before our next stuff. But work session on Wednesday on the 4 bills that we've heard this week.
One other quick question, Charlotte. Is the drink water thing that's in effect? That's it?
Water or coffee or
Coffee,
whatever you
okay.
want in committee room.
Coffee,
Yeah.
okay.
Yeah. Yeah.
Lois, there was your bill, no, not your bill. There was another bill that's similar to yours about the academy membership. And we're skipping that until yours is ready because they're both the same. We'll do it some other time, okay? Okay, good.
Great. Everyone have a nice long weekend. Democrats, can you respond to me about when you want to do our caucus before Wednesday? I sent you an email and I've only heard from a couple of you. Thank you.
Yeah.
Have a nice weekend, everybody.
Bye-bye.
Have a good weekend. Bye.
Dan, I'll call you.